What's commonly referred to as rape elsewhere is legally called sexual assault here in the state of Nevada, and it requires sexual penetration, however slight. It does not necessarily have to involve intercourse. It's without the consent of the party or under circumstances in which you reasonably should have known that the person was incapable of consenting.
A common example of that would be someone is passed out, drunk, or on drugs, so they're not able to understand what's taking place.
Ultimately, the issue of what constitutes penetration is up to a jury to decide. The instruction itself says that any penetration, however slight, is sufficient. But we're often actually debating at trial whether a penetration occurred, if it was touching on the outer lips, for example, of the vagina, or if there was a licking, how far, literally, how far in did the tongue go? And these are questions for juries to decide as to whether or not there's actual penetration.
If a prosecutor here in Nevada believes that someone tried to sexually assault someone, but there was not penetration, then they could be charged with the crime of attempt sexual assault, which carries slightly less penalties of 2 to 20, as opposed to a possibility of 10 to life if you're convicted for sexual assault.
If there's substantial bodily injury, it's life with parole after 25 years or life with no parole at all.
Also, for any sexual assault crime, if you are convicted, there will be lifetime sex offender registration.
We find that a lot of innocent people get wrongly accused of rape. And this happens really for a number of reasons. First of all, there's a lot of false accusations. A lot of times the accuser will make accusations out of anger or jealousy or spite. We've seen situations where a guy was dating a young lady and she wanted to take the relationship further and she wanted to be exclusive, and he didn't want to do that and wasn't giving her the attention she was seeking. And she felt insulted and she felt hurt and made false accusations out of spite to get him in trouble. And situations like that are actually very common. We also find a lot of times the accuser will make a false accusation of rape in order to get attention. A lot of times the accuser has mental health issues. The accuser is a narcissist. And the accuser likes the idea that they're so desirable that other people are desperate to have sex with them and desperate enough to commit rape. And so they imagine things and they make false accusations to try to create this reality as part of their mental pathology. We see this very commonly. Also, a lot of accusations of rape arise out of a misunderstanding. So it may be a situation where you went out with someone and you guys were making out and there was foreplay and you ultimately had sex with the person. But later the person says, oh, I didn't really want to do it, but I was scared to speak up. I was scared to say no. It was against my will. But if that person didn't communicate that to you, and based on the circumstances, you honestly and reasonably believed that they were into it and that it was consensual, then that's really not a rape.
There are many defenses to sexual assault. And notwithstanding the fact that these charges are very serious and it's very scary if you're charged, in most circumstances, we come to learn that there are two sides of the story, and the issue of consent is often very murky. If we can show that our client reasonably believed that the other party was consenting, we can win a not guilty verdict because the state has to prove that the sex occurred without consent. Again, often that's murky, and when it's murky, it's hard for the state to win a conviction.